Okay, good afternoon. I hope that you can see me and I hope that you can hear me. If you can't, please let me know. I see we do have a few people here already. So please, just in the comments, I would be really grateful if somebody would just indicate whether you could see and hear me, please, while I'm grabbing another document. Okay, so, thank you so much, Gabby. It's much appreciated. So, what are we doing today? And I hope that you can also see the text of section 36 here at the back and the stage or the two-stage approach that the Fuss and Friedman and the other authors have summarized for you, because it's really important to just bear this in mind as we go through the cases. What we are doing now, just to get everybody on the same page, is we're busy with a second study unit for the semester. It's all about the limitation of rights, because no right in the bill will apply without any limitation. We will always have, we will always have a limitation of rights allowed, and as long as this limitation complies with section 36 of the Constitution. So one of the students, Lebogang, wrote me a very nice, very professional email, and he wanted to know about the balancing and about the procedure. So I thought it might be a good idea just to take some inspiration from one of the earliest cases where the limitation inquiry was done, and that is the case of the New National Party versus the Government of the Republic of South Africa and others, and it was reported in 1999. And if you want to go and read it, it is 1999 3 SA 191, New National Party versus Government of the Republic of South Africa and others. So I'll just use those facts as an explanation. So what do we mean by limitation of rights? So everybody knows that every adult citizen in South Africa has the right to vote. So if you look at section 19.3a, and I just want to read it from the Constitution, it says that every adult citizen has the right to vote in elections for any legislative body established in terms of the Constitution, and to do so in secret. So, given our history, we know that this is a particularly important right because of the fact that it was denied to the majority of citizens for such a long time. However, if we go into the mechanics of elections and we read the Electoral Act, we will see that only adult citizens who are registered on the voters' roll may vote. And you can only register on the voters' roll and vote if you have a bar-coded identity document, either that green booklet or the identity card that is issued when you become 16 years old. So in the case of the New National Party, that requirement was contested because it was argued that the requirement of having the bar-coded ID, of being registered, etc., was a limitation of the right to vote. And let's just for a moment take these two limitations and we use section 36 to have a look at how this should be done if we work with Section 36. So, what is the first requirement that we must, or the first inquiry? The first inquiry is the threshold inquiry. We must establish whether we're actually dealing with a right that is protected in the bill. And if we are, how far is the protection that this right is giving or affording? So if we read Section 19.3, that is the fundamental right, the right to vote. And that right is extended to all adult South African citizens. And beyond that, there's no qualification to the right. So that is the right that we are looking at. And if we are now considering the requirement of the ID and the voter's roll, etc., we can say that these measures limit this very broadly formulated unqualified right in Section 19.3. So if we have passed the threshold inquiry, we have seen that we do have a fundamental right that is now limited. And in the second instance, that this is indeed limiting, or these measures that we are considering are limiting this right, then we go into the next phase. And that second phase is what most of the work in the study unit is all about. And what is the first question? Pardon me, I don't really see the slides in front of me, so I'm just going to open my file quickly. And what is this inquiry? The second phase is the justification inquiry. And the justification inquiry also rests on two different aspects. And the first one is, do we have a limitation that is contained in a law of general application? Why? Because if you have a look back at Section 36 there, 36.1, it says it may only be limited in terms of a law of general application. Where are these limitations contained? They are contained in the Electoral Act. Where does the Electoral Act come from? It is a national act that was passed by Parliament. Does it apply to the entire population in South Africa? Yes, it does. It is not just aimed at one or two or a certain limited category or class of citizens. So it was passed by an authorized legislature, Parliament. It was validly published, or it was validly passed, it was published, it's accessible, it is clear, everybody reading it can immediately understand what it requires of voters, and it applies to the whole country. So yes, the Electoral Act and these provisions can be seen as laws of general application. It's a law of general application limiting the right. So we are past the next inquiry. And now the last one is the most complicated, and it is the justification inquiry. Now, or the question whether this particular limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality and freedom, taking into account all relevant factors, including the 5 that are listed, but obviously not limited to those 5. So here we see that up to now, our inquiry was quite mechanical. We asked, do we have a right in the bill? Yes, we can identify the right. Do we have a limitation that infringes this right? Yes, we can do that. Is this limitation contained in a law of general application? Yes, it is. But it's easy up to now, if you wish. Now it gets complicated, because if you look at the wording, you immediately see that this will be a complicated inquiry. we need to now make a judgment on what is reasonable, what is justifiable in an open and democratic society based on human dignity, equality, and freedom. These terms are loaded, and these terms are not always as straightforward, or the concepts are not always as straightforward as we may think. So now we get into the thick of things. Now we are really getting into the inquiry. And this is where we weigh up the two sides. We, on the one hand, we have to look at the right that is protected in the bill, Section 19.3, the right to vote. On the other hand, we have these limitations, the requirement that a person must be on the voter's roll and must have a barcoded ID. And this is where the question came in. Why do we say we are weighing up different rights or different interests? The reason is that we need to look at both sides. We can't just look at the one side, looking at the right and not considering the limitation, or only considering the limitation and not the right. So how will we go about doing this? We now need to look at the right, at the limitation, as well as the relationship between the two. What do we mean by that? Go back to those factors listed in Section 36. We need to look at the nature of the right. What is this right? The right to vote. How important is it? It's crucial because it is protected in the Constitution. Democracy is a founding value. Given our history, it is one of the cornerstones of our constitutional state. Who is protected? Everybody in South Africa is protected. Why is it important? Because a lot of our citizens, majority of our citizens, were not granted the benefit of this right during the apartheid era. So this is what we have on the one hand, very important, crucial right that we are looking into. On the other hand, now we're looking at the limitation, this requirement of the ID. Why do we have it? What is the purpose? The purpose is to ensure that it's only South African citizens and only adult South African citizens who actually vote. Why does the Act require an identity document with a barcode? We get an identity document with a barcode when we turn 16 years old, free of charge. First one is supplied free of charge. And why does it have a barcode? So that it can be authenticated, so that it can be linked to my personal data that is in possession of the Department of Home Affairs. Is it difficult, or let's just go into this. So, is it a legitimate purpose to try and ensure that only South African citizens, adult citizens, vote? Of course it is. Of course it is a legitimate goal. Sorry, I just want to say something on the comments. I'm at the NWU, and it's supposed to be a very good, the connections are supposed to be good. So if you are having trouble hearing or seeing, I will have to look at the recording and perhaps edit it and then upload it again. For those of you who are not having troubles, you should be grateful, because for some people there's a problem with the sound apparently, and or the visuals. Apparently the sound is not a problem. Now, let's get back to our inquiry. We have the right to vote on the one hand, we have the limitation, the ID requirement on the other hand. It's definitely a legitimate purpose to ensure that only adult South Africans vote. Because if we don't have the safeguard, everybody can pitch up and ask for a ballot, and their vote will be counted. And this will be counterproductive. This will be in conflict with other rights in the Constitution and other values, the value of democracy and the right that every citizen also has for regular, free and fair elections. So, not only is this requirement serving a legitimate purpose, we may even argue that it's necessary to ensure that all other constitutional ideals around elections are served. Can this limitation, this requirement of the ID, attain the goal to ensure that it's only adult South Africans? Yes, because that's the way that I prove who I am, what my date of birth is, and that I'm a citizen. Is it difficult for me to comply with that? No, because every South African over the age of 16 should have an identity document. Does it infringe the right substantially, my right to vote? No, it does not take away my right to vote. It does not take away any South African's right to vote. It only requires some effort for me to ensure that I can verify my own identity, that I can prove I am who I say I am when I want to be registered on the voters' roll or that day when I want to go and vote. So, this is then the summary. The limitation is serving a legitimate purpose. There's a rational connection between the limitation and its purpose, because requiring that people come with their IDs can actually ensure that we only have adult South African citizens voting. So there's a rational connection. It serves the purpose. It's a very important purpose because we need to have free and fair elections. It's not very difficult for me to comply, for the average voter to comply, because you have an ID anyway. What else? Is it limiting the right to vote in its core? No, it's not. Everybody can still vote. We just need to verify our identity. So, if we look at all of this, we will see that even though the right to vote is a really important right, this limitation is also serving not just a legitimate purpose, but probably a necessary purpose. And if we weigh up all these interests, we will come to the conclusion that we are having a justifiable limitation. Just give me a moment, please. I just need to check up on something here on the settings. Just a moment. Yes. Let's try and see what happens here. So, let's continue. What you can also do, the other way in which it is summarized is if you look at the Force and Friedman's approach on page 363 to 379, you will see that they also run through this inquiry. They ask, is the purpose of the limitation legitimate in an open and democratic society? Yes or no? Is there a rational connection between the limitation and its legitimate purpose? Is there an alternative, less drastic way in which the same purpose can be attained? I can't think of any alternative or less drastic way in which I can go and prove my identity when I want to exercise my right to vote. So in this instance, it's a no. In other words, then the last question, is the limitation proportional, taking into account the extent of the infringement that we have already said is not a great extent. It's a minor infringement. The nature of the right, it's a very important right. The extent of the limitation, it's not a great limitation. And the social good that it achieves. The social good is here to ensure that it's only adult South Africans voting. So, yes, we will come to the conclusion that this is indeed a proportional limitation. And because we have a rational connection, because we have a legitimate purpose, because it is a proportional limitation, it's a justifiable limitation. And that is also what the court found in the New National Party case. It found that the limitation was justified and that the sections in the Electoral Act were valid. And that is what limitation of rights is all about. So what were the cases that you had to go and read? And as you might have noted, the freedom of religion case versus Minister of Justice and others, the 2020 judgment, is of course the topic of your assignment. So please don't expect that we will go into any great detail at this stage, sort of giving away the answers. But what we will do is we will have a look at the EFF case and we will quickly run through what was decided there. The economic freedom fighters and another versus Minister of Justice. Now, not only does the EFF ensure constant work for all the news reporters, they also ensure that we have material to work with. And for that, if not anything else, we shall be eternally grateful to them. Because it's amazing to see how many of these constitutional law cases are either brought by or against or brought by the EFF or involve one or more of its leaders. So what happened in this case? It all started, and of course we know that the leader of the EFF is not a person who is afraid to speak his mind. So what happened? What were the facts that gave rise to this particular case? He, during a number of gatherings of the followers of the EFF, told people to occupy the land, take back the land, occupy land, in contravention of certain legislation. He told people to take back the land, go grab the land. And these, of course, to do that, you would contravene a whole number of laws. One of them would be you will contravene the Trespass Act because you are not allowed on somebody else's property without their permission, number one. And also the Extension of Security of Tenure Act and the Prevention of Illegal Eviction from and Unlawful Occupation of Land Act prohibits unlawful occupation and eviction of people. So what he was actually doing is he was telling or instigating, that was the case against him, the prosecution brought this case against him, that he was instigating his followers to go and commit crimes. Those crimes being trespass and contravening these the ESTA and PI Acts. So they charged him with incitement to commit crimes. Now, the crime was defined in the Riotous Assemblies Act. Now, that was an old apartheid act, but it is still valid. And what it says, or what it did, is in section 18.2, it says that anybody who incites somebody else to go and commit crimes is also guilty of a crime. So if I now go and tell my child, go and steal that bread, I'm also guilty of a crime. Perhaps not the crime of theft, but definitely the crime of instigation to commit theft. So Mr. Malema was charged with instigation to commit crimes. What was his response? His response was the section in the Writers' Assembly Act, that section stating that inciting somebody else to commit a crime is unconstitutional. Why? Because of the right to freedom of expression. He said, my right to freedom of expression is protected in section 16, and if I go to a political rally and I want to speak to my followers and tell them for political reasons that we need to take back the land, the Constitution protects me from to do that. So what did we have here? We have the right to freedom of expression on the one hand. On the other hand, we have this particular act in the right, or this particular section in the Writers' Assemblies Act stating that it is a crime to incite somebody else to go and commit a crime. And these are the two things that we need to weigh up here. So what did the court do? Of course, the first step was to establish what is protected by the right to freedom of expression. What kind of speech is protected? And the court investigated what the provisions of section 16 are. The court then lodged the limitation inquiry. And the question here was whether the limitation is reasonable and justifiable in an open and democratic society based on equality, human dignity, and freedom. So, what did the court find? What the court did, and pardon me, but I'm just going to read here and there from our summaries. The court, in essence, found that the crime of incitement itself, the fact that it's a crime to incite somebody else to commit a crime, is not an infringement, or not an infringement, yes, an infringement of section 16.1. In other words, the court found that it is a justifiable limitation of the right to freedom of expression. Just to rephrase it, the court basically said, you have the right to freedom of expression, we recognize that, but that expression does not extend to go and tell other people to go and commit crimes. So the court said that the fact that it's a crime is constitutional, it can be justified, and we'll have a look at the analysis just now. However, the fact that the Act went further and said everybody who is now guilty of the crime of incitement can be punished as if they committed the crime, that was unconstitutional because that was disproportionate. And we're just going to go back to that. So what did the court do? The court did, in fact, go into the 5 factors. The court accepted that the Writers' Assembly Act was a law of general application. The court looked or investigated the freedom of expression and said that it is a very important right. It definitely must be protected, but our law also recognizes that it may be limited. For example, the crime of crimen injuria. I can't go around saying to people whatever I want to say or go and defame people. There are limits to how I can and should express myself. So, on the one hand, we have this important right. but it can be limited. On the other hand, the limitation. What did the court do with the limitation? It said the purpose of this crime of incitement is to prevent crimes. It's better to prevent crime than to try and address it once it's been committed. So it will serve the purpose of preventing crime if we tell people it's not okay to go and tell others to go and commit crimes. I'm not supposed to tell my child to go and steal that bread. Now, it's important, the court said, for law and order, because we do not live in a society of fear marked by the threats of acts which have already been determined as undesirable and unlawful. So, the court said, although it's necessary to recognize that we have political freedom of speech and that it extends to your political views, and it's necessary, but you can't extend that freedom of expression from being a political view into going to commit crimes. I can express my political views, but I should not be allowed to tell my followers to go and commit crimes. So, in other words, the court said that this limitation in the Writers' Assembly Act serves this purpose. The nature and the extent of the limitation, the court said, is marginal. It does not relate to the core of freedom of expression. It's only peripheral. It's not a full-out prohibition to expression. So I can still express my views. I can still express my political views as long as I don't tell people to go and commit crimes. So what the court also said is the court said there's definitely a rational connection between the limitation and its purpose, because it definitely will contribute to the prevention of crimes. And then the court found that the crime itself could be a justifiable limitation of the right. However, the punishment was not, because this was not in proportion if the court weighed up the interests on both sides. So, what will be required is that you need to reread the judgment and just have a look whether you can identify the different steps as we have them on the slides here. Can you see where the court, or whether the court went into the question, the threshold inquiry? Did it go into the question whether we have a law of general application? And how did it then conduct the justification inquiry? Did it follow these steps that the Fuchs and Friedman proposed? Did it follow the Constitution? Or what happened? And that is a critical evaluation. A critical evaluation is you need to have a look at what the law says. Section 36 requires. What do the authors say? How must we use Section 36? And what did the court do? Did the court follow all the steps? Did the court stick to the factors listed in Section 36, or did it actually consider other factors as well? Did they follow this sequence that the Fuchs and Friedman proposed, or didn't it? Does it make a difference? So, ladies and gentlemen, very important, also for purposes of the assignment. You're not required to evaluate the EFF or the EFF's behavior, or whether taking back land is should be a topic of discussion at all. What you are required to do in this context is to evaluate the judgment regarding the limitation of rights. Did the court do what it was supposed to do? And do you agree with the way in which the court did it? Do you agree with the way that the court weighed these different interests or the two sides or not? And that is what you are also supposed to do for the assignment. What you are supposed to go and do for the assignment, of course, is to have, after you've read it, ask yourself, what were the facts that led to this matter landing up in court? Briefly, what were the facts? Which right, which constitutional right, which right in the bill, or rights, were under threat here? On the other hand, what was the limitation? Was this limitation contained in a law of general application? What was the purpose of the limitation? Is there a rational connection between the limitation and the purpose? How far does it infringe the right, etc.? Did the court look into all of this? So you need to go and summarize what the court's findings were, and then in the second instance, critically evaluate what the court did in its judgment. Did the court approach this correctly according to you? No need to go into a huge analysis of the desirability of corporal punishment or not, because that's the case. The one that all the parents in South Africa took note of at the end of last year. But the question that you have to answer is, how did the court deal with the limitation inquiry? So, on this note, I'll say goodbye for now. Please remember to ask questions, and I will check and see if we should edit this video. I do apologize for the streaming quality. I came to campus to try and get the best internet possible. Let's hope it works. And by the way, look after yourselves and stay safe. Bye.